Good morning. Are you David Boyd?
Yes, ma'am.
And Mr. Boyd is charged with deadly conduct, discharging a firearm, in cause number 250720. And Mr. Kelly's here for Mr. Jeffries. And what is the announcement?
Your Honor, I think that there is some media, either video or USB, that we might need to get the mic on.
Are you talking about additional media or just the media in the case?
Just media.
Okay.
Do we have it already?
I'm not sure. I thought maybe you were suggesting that there was something out there that we would here. I'm sorry.
All right, I'll just do a normal reset, make sure Mr. Jeffries gets that request in. Mr. Boyd, stay in touch with Mr. Jeffries so that as soon as he gets all that discovery, y'all can go over it and we'll try to get an announcement at the next court date.
Yes, ma'am.
All right, thank you. Request number 24, DCCR 2310 on Ciandre Stevens. And are you Ciandre Stevens?
Yes, ma'am.
Ciandre? Sorry. And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
And do you fully understand them?
Correct.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Answer out loud, please.
Oh, yes, ma'am.
Thank you. The court reporter's taken everything down. And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Correct.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
I have to ask everyone that. State tenders number 1.
No objections?
It's admitted. Is there any evidence that Ms. Stevens is not competent?
None.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see y'all back at sentencing. Thank you.
All right.
Thank you, sir.
Thank you, Judge.
All right, sir, you're Avery Young. And Mr. Young, in cause number 24, DCCR 1939, you're charged with the state jail felony offense of burglary of a building, and that's from August 9th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand? And I have here on the computer a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 21-month term in the state jail prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And you understand all of that. And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
And Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge. In fact, Mr. Burbank actually made a counteroffer just a few minutes ago, and I'm amenable to that counteroffer if the defendant will take it today. It would be pleading to a misdemeanor criminal trespass with 6 months in county jail.
And so, Mr. Young, obviously you've gone over that with Mr. Burbank. I just want to make sure you understand that that offer would be off the table after today.
That's fine.
All right, we'll get it set for trial. Is there any issue with discovery? You'll have everything? All right, we'll set it on the trial docket. Stay in touch with Mr. Burbank. He'll let you know when you need to be back and ready for trial.
All right, thank you.
I see that. Any excuse?
All right, Mr. Mitchell, we brought you into court today because of some issues with regard to, I think, the drug patch and how it's testing. You tested negative today, which is great. I just want to make sure that you are changing it when you're supposed to, showing up on time, making sure it gets changed, and obviously negative on each time. And I see Mr. Burbank just handed me, this was a hair follicle test that also tested negative. So appreciate that. So I guess, is there anything that we can do today as far as an announcement, or do we just need to reset? It is already on the trial docket. We'll put it back on the trial docket then. But again, make sure you follow all of the rules and conditions of your bond with regard to that drug test.
Pertaining to my funds and the incarceration for this matter. What? Or would be, it was a hair follicle taken. I was wrongfully accused of the drugs that were in my system.
What?
No, it was positive on
It showed a positive on the patch, and that's why we came in. There are times, sometimes there's false positives, sometimes there's not. It all depends, but that's why I brought you in here, because I did receive a patch result that tested positive for cocaine. And so I wanted to make sure we're all on the same page. You keep up those drug patches. You did the right thing by going and getting a test, so we should be fine. But just stay in touch with Mr. Burbank, follow all the bond conditions, and we'll see you back on your trial date. All right?
Are you the excuse, Judge?
Yes. Perfect. Are you Diamond Smith? All right, so I'm going to reset the case, make sure, give Mr. Hoffpower some time to get everything worked out that he needs to, get any information to Mr. Burbank that he needs to have, and let's see if we can get an announcement at the next court date. All right, make sure you stay in touch with Mr. Burbank. He'll let you know when you need to be back.
The excuse, Judge.
Yes, thank you. Thank you.
Talk to you, Judge.
Ms. Norman on Edwin Lopez. Good morning.
Good morning.
Your Honor, when you're ready, the state's going to abandon the, I think we spoke to you earlier about it, we're going to abandon the last sentence of the indictment, which says the motor vehicle language,
Okay.
and that sentence ended at defendant.
Any objection to that, Ms. Norman?
No objections, Your Honor. It's to be a Class A misdemeanor from this point forward.
All right, let me,
And I think we reflected that on the paperwork.
y'all did. Let me see if I can. Look, I'm able to. I just struck through a sentence on the computer. I'm just, for everybody's information. Thank you. I need that.
Hey, whatever helps.
It does. Okay. Mr. Lopez, he waived the formal reading of the indictment as amended.
He will.
Mr. Lopez, in cause number 24, DCCR 1908, the state has elected to, well, you're charged now with the Class A misdemeanor of evading arrest or detention, and that's from July 24th of 2024. And how do you plead to that charge? Hold on. Y'all marked it as a state.
The lesser included.
Was it on the state bill paperwork, Judge?
Yeah.
Needs to be. All right.
I think we can make it work.
And right away the judge is sorting out evidence issues USB's media files confusion classic early hearing chaos. Notice how she keeps the room moving anyway. Judges don't like delays, but they hate surprises even more.
The other paperwork just has a place where we can fill it in,
As opposed to write it.
because none of this, all this community supervision stuff doesn't apply on state jails. They're specific. I hate to do this, but would y'all please do it on the TDC paperwork, because it has a blank spot where you can write in Class A what the range of punishment is on all of that, and it doesn't have this special language that has to do with upfront time and all that. So I'm going to delete it, and as soon as y'all are ready, I'll take care of it.
Just start over, we're not sending it back, right, Judge?
No.
No, we're gonna have
Brand new paperwork.
Right, okay.
Yes,
Perfect.
on the do it on the TDC, which obviously it's going to be a Class A. It just is easier on the TDC than it is the state jail.
No problem.
Okay, and so Mr. Lopez, we already went through. Did we already get a plea and all that? Where'd we stop?
No, you stopped
We did
right away.
right away. Okay, and will he waive the formal reading?
Guilty, though.
Okay, let's just start over so the record's clear. And will he waive the formal reading of the indictment as amended?
He will.
Mr. Lopez, in cause number 24, DCCR 1908, you're charged with a Class A misdemeanor of evading arrest or detention on July 24th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Norman?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement that you've reached, my computer's, is for a 2-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
And Are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Lopez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay a $500 fine, follow all of the rules and conditions. And if you do that, then this is an excellent opportunity because you don't have a conviction on your record. And if you successfully complete the probation at the end of that time period, the case will actually be dismissed. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sentenced to the Jefferson County Jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to stop and talk to probation on your way out of the courtroom. She might have you sit down for a minute while she gets the paperwork ready, but just stop and talk to her, and she'll let you know what you need to do with probation. All right? Good luck to you, sir. Thank you. Edwin, nay?
Yes, ma'am.
Okay, thank you. Give me just a second to get back where I'm supposed to be here. And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor, we will.
Ms. Johnson, in cause number 24, DCCR 2151, you're charged with a third-degree felony offense of forgery of a financial instrument from August 10th of 2024. And how do you plead to that charge?
Yes, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
Your Honor, can we change it to no contest?
Nope, I don't take no contest. Or I know only under certain circumstances, but typically not. And then, Ms. Johnson, in cause number 24, DCCR 2152, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from September 18th of 2024. And how do you plead to that charge?
Yes, ma'am.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
And then finally, in cause number 24, DCCR 2153,
Here's something most people don't know when a judge says stay in touch with your attorney. It's not a polite suggestion, it's survival. Miss a call or ignore discovery, and you can tank your own defense before the case even starts.
you're also charged with the state jail felony offense of abandoning or endangering a child with intent to return from September 18th of 2024. And how do you plead to that charge?
That's the same charge. You have the 2 counts.
Same charge with 2 different
Yes.
children, correct?
Yes, ma'am.
All right, so how do you plead to that one?
Yes.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
In all 3 of these cases, I have here on the computer some documents that have your signature on them, that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Frazier?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreement that you've reached in the third-degree felony is for a 6-year deferred probation with a $500 fine, and you would be required to follow all of the rules and conditions of probation. And then in the 2 state jail felony cases, it would be a 5-year deferred probation with a $500 fine, and again, you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence? Well, it looks like there's no fine in 2153. So is it 500, 500, and then none?
Yes.
Okay. Any evidence that Ms. Johnson's not competent?
No, Your Honor, he's confident.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That will give me more information about you and your cases, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Lofton, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You need to speak up, please, sir. And will your client waive the formal reading of the motion?
Yes, ma'am, we will.
Mr. Lofton, in cause number 16-24485, I have a motion to revoke your community supervision. Shows that you were placed on probation February 21st of 2020 for the offense of assault family violence, and that was a 10-year term in prison that was probated for 5 years. Is that correct? It alleges you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated second on December 15th of 2023. And is that true or not true?
True.
And count 2 alleges that you failed to pay your court-assessed fees as directed, and as of December 20th of 2023, you were $5,946 behind. Is that true or not true? Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
So I'm going to find that you enter those pleas true freely and voluntarily, find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing and have the probation department do an updated pre-sentence report, give me more information about what's been going on probation with the new case and everything like that, and then we'll come back at a later date for sentencing. And so you need to stay in touch with your probation officer, stop and talk to the one here in courtroom before you leave today.
Judge, it's my understanding that he's going to plead to a short jail time down in misdemeanor court. Obviously, we'd have to do at least the 72 hours, probably about 10 days. So he may be in custody when the update PSI comes back.
Okay,
And that is in contemplation of the fact that if the court agrees after the update, he will go to ISF and spend additional time in custody.
in the substance abuse track, I would think.
Yes, substance abuse track with an extension of his probation, because obviously it was just told by the motion it's already
Right.
expired.
Okay,
And Your Honor, just for clarification purposes, is my understanding from talking to the misdemeanor prosecutor that that any time he spent in an ISF would count toward whatever sentence they assessed down the hall.
okay. So let's do this. As soon as that happens,
Which is set on the 25th.
25th.
okay. So let's reset it just 1 week after that. Can y'all get that done in a little shorter time as on the update? It's okay. It's an update, so it's, because I also want to make sure,
So if it's after the 25th, the following Monday, we'll not do it, it'll have to be September 8th.
This is a pivotal moment admitting to a DWI second and nearly $6,000 in unpaid fees when a defendant pleads true. The legal battle shifts instantly. It's no longer about proving the violation, it's about damage control and what the judge thinks is fair.
Is there any way we could,
We might could put it on the 2nd. That's a Tuesday. If he's in custody, we could put it on that Tuesday.
do we have a docket that day? Let's do that.
I am
September 2nd? Yes, ma'am.
I am set for trial on September 2nd in Jasper. Is there any way,
What about the 26th? Are we here?
Yes.
I'm fine with that. Of August? Mm-hmm. That's fine with me.
Is that okay for an update? Okay, we'll do it on Tuesday, August 26th. And that'll give you time to get that one, and then we'll need it be on a Tuesday anyway, now that I'm thinking about it, because he'll be in custody.
Right.
So, yeah, okay, perfect.
So
All right.
I need to get, for that hearing on the 26th, will I just go to the jail and do it?
They'll bring them over.
Oh, okay.
Yeah, we're bringing them over.
Don't tell my lady. A rare moment of humor breaking through the courtroom tension. Judges see everything. Fear relief jokes panic. These human slips remind us that courtrooms aren't cold machines. They're full of people trying to hold their lives together.
So we'll see you on Tuesday the 26th once you're in custody, and we'll get
I'm
that
not going
update.
to
Not you. You're like, I'm going home.
We haven't decided that.
You're not out the door yet, Mr. Barrington.
Don't tell my lady.
You're free to go.
I agree with you. Thank you, Judge.
Thank you.
Deferred probation is a legal tightrope, no conviction now, but a single misstep and it snaps. Judges offer these deals as a second chance, but make no mistake, the state is watching closely. The question is always, can the defendant stay the course? This is courtroom strategy in real time. The defendant rejects a 21-month deal, bold move, but the prosecutor fires back with a new offer, a misdemeanor, and only 6 months. These negotiations aren't random, they're psychological chess, and one wrong decision changes a life.